How can I document abuse legally in a two-party consent state like Florida?
I can't tell you how many times I've had clients come to me and say, I have this video and I want to use it in court. And I always have to ask two questions. One, where were you when you made the recording? And two, did he know you were recording? In order to understand how to record someone being abusive without violating the law, the first thing we have to do is understand the law and what it prohibits. What the wiretapping statute prohibits, relevant here, is that you cannot record audio of someone without their consent if they have a reasonable expectation of privacy. So what does that mean? If they're inside your own home, you're in a car, anywhere where basically no one can hear you and there's no expectation that someone else can hear or see you. Usually what that means is that if it's outside, so in the garage door's open, on the deck, on the porch, outside the car, even if it's on your property, if it's outside, you have lost that reasonable expectation of privacy. So what does that mean? You cannot record someone without their consent if you are inside your home. That's a pretty clear line. I also think it's important to talk about the difference between legality and admissibility in court. Legality is about whether or not you're violating a law, a statute, a code, a rule, something in the laws. It is illegal, it is a felony to wiretap someone or to record them without their consent, including audio, when they have a reasonable expectation of privacy. That is a crime. The other question is it admissible in court? And this is where we talk about, just because you can doesn't mean you should. So I would argue that videos taken in violation of the wiretapping statute are actually admissible in court if the person who took the video is the one introducing and authenticating the video in court. But this is what I always tell my clients. You don't want to put in court, on the record, in front of a judge, evidence that you committed a crime. So it's admissible, but it's illegal. So what can you do? How can you document the abuse? Well, for one, you can record someone outside. So if something's happening and you're able to get outside and press record, that's not illegal and that's completely admissible in court. Take pictures. Pictures are not audio recordings. Pictures are admissible if the person who took the picture is there to authenticate it. If you, as the survivor, are inside and your partner is abusing you, you can take pictures. If you get him outside, you can take a video. It's also very important to document things after the abuse. Property damage, broken dishes, holes in walls, pictures of bruising, any sort of injuries, scratches, whatever it may be. And the thing about bruising is bruises develop. You take a picture every day or as much as you can from the day it happened until usually the worse the bruise might get. You want to show a progression because it usually takes a few days for that bruise to really show up in its full force. You take a picture day one, it's a little red, there's a mark. Day 4, it's a welt. You want to make sure you get that mark and you get the welt in the same spot so you can show that this is the injury that was caused by the abuser. Another thing when we're talking about documenting abuse is a timeline. So this isn't going to be something that will be admissible in court, but it is something that would absolutely help you and your attorney preparing for court and preparing your testimony. Abuse is trauma, no matter what. And we know that the brain on trauma does not store memories in the same way as a non-traumatized brain. In those moments that you're experiencing abuse, you're not going to be able to remember every single detail about what happened. What is very important to do for the purposes of a court case is to later, after you have calmed down, you are regulated, write down as much as you can remember. And then eventually you can put together a timeline of the abuse. Important things are dates as much as you can remember, time, even if it's just time of day or how long something happened for. You don't need exacts. Don't guess, estimate. That's always my rule. You don't need an exact date if you don't have one. Don't guess. Approximate. It was sometime in early spring, late through last year, things like that. I just want to make one final point here that there are some exceptions, and the big relevant one here being the injunction exception. So there is an exception to a violation of the wiretapping statute that says that anyone who has an active injunction, which is a civil restraining order in Florida, so if you have a temporary or final injunction of any type, you are allowed to record someone who is violating that order. You don't need their consent. It doesn't matter where you are. If they're violating the injunction, you can record them and you can use that in court and you can give that recording to the cops. I recently made a video about how to record someone in Florida without violating Florida's two-party consent state laws, and I got some really good questions, and I wanted to do a follow-up video and try to address some of these. One of the questions I got on this video was, does a video with audio removed violate the statute? As I explained in my last video, The statute is about recording audio. This is one reason security cameras that don't record audio might be very helpful in a situation like this. One, because usually if you have security cameras around the house, the other party knows they're there. And two, again, if it's not recording audio, you don't have this problem with this statute. But the other thing I wanted to address with this comment is this idea of removing the audio after the fact and how that might get you into trouble in a few ways. In my last video about this topic, I talked about the difference between legality and admissibility. This is going to give you a big admissibility problem because in order to introduce a video into evidence properly and have it be admissible in court, the person who's introducing the video has to authenticate it as being a fair and accurate copy of the video at the time it was taken. And if you have made any edits post taking the video, it is no longer a fair and accurate copy. The point of authentication is to prove that it has not been edited or doctored in any way from the time the video was taken to the time it's being introduced into court. So this would cause a lot of problems with that. And you also want to avoid any other potential implications of editing the video that might make it seem like you made other kinds of edits besides just removing the audio. It sort of gets you into a lot of trouble when you start changing evidence after the fact to fit into the rules of admissibility. And finally, the last thing I wanted to say about this is the statute was violated at the time the video with audio was taken. So removing the audio may help you from subjecting yourself to criminal liability by introducing the video into evidence, but that would be if nobody knew that you removed the audio, which would require lying under oath when you're trying to authenticate the evidence. So there's a ton of other problems that come with this, and I really don't recommend it. Another big thing I want to talk about here is this idea of implied consent and how that can actually help you in recording a video inside a home or inside a car without violating the statute. If you hold your phone up when something is happening in a situation where the other party has a reasonable expectation of privacy and they have not consented to being recorded, if it is very obvious that you are holding your phone up and recording them and they continue to behave and to act on camera, you can argue, and it has been successfully argued, that they gave implied consent to be recorded when they continued being on camera after it was very obvious that they were being recorded. Of course, you also have to think of your safety here. If you hold up your phone and it's very obvious you're taking a video, if they smack it out of your hand and then retaliate, is that worth it? You have to weigh the risks and benefits of doing these things no matter what, especially if you are in an abusive relationship and attempting to document it. There are always safety considerations that have to be discussed when you're documenting abuse while you're still in the relationship. The last thing I wanted to say about the two-party consent laws in Florida is that when you're introducing something into evidence, some kind of video, the controlling laws about the legality of the recording are based on the state it was recorded in. If you are introducing something in a Florida court that was recorded in another state, and that state is a one-party consent state, and you didn't get the other party's consent to make this recording, you can use that in a Florida court without subjecting yourself to criminal liability because the rules that govern the legality of the recording are the rules of the state in which the recording was made. As always, these things are complicated. It depends on 1,000 factors. That's why the famous lawyer answer when you ask them a question is always, it depends, because it does. Speak to an attorney to get tailored advice about your specific situation. This is information. It is better to be armed with information than to not be. Thanks for listening and stay safe out there, everyone.